Welcome back to the Loud Little Ducky. We are going to be discussing and going over the filings that Laura Owens has submitted in the DVRO renewal case against Mike Marraccini. Now, she wanted a continuance, and she makes some new statements in her declarations about why. And so let's look at those and discuss what is going on. What is she trying to pull? Let's get cracking. So the first one we're going to go over was submitted on October 7th, 2025. And so Laura Owens is petitioner in pro per, which means she is representing herself at this time. And it's an ex parte application for continuance of a hearing that is currently set for October 21st and 22nd of 2025 in the Owens v. Marraccini matter. Introduction. Petitioner Laura Owens respectfully requests that this court continue the long cause hearing currently scheduled for October 20th and 21st and adjust all related deadlines. Good cause exists under California Rules of Court Rule 3.1332C and D because of petitioner's medical condition, her father's recent hospitalization, and her ongoing yet diligent efforts to secure counsel through approved legal referral programs. This matter has been designated a long cause evidentiary hearing, not a short or summary proceeding, given its complexity and overlapping motions and the public nature of the record. Petitioner cannot adequately represent herself. A short continuance will allow her to secure counsel and participate fully and fairly. The public nature of the record? Okay. I don't see really what that has to do with, but... Oh, yes, I do. Yes, I do. Never mind. All right. Factual background. 1. Family medical emergency. Petitioner's father was hospitalized last week and continues to require 24/7 care. Petitioner has been assisting daily with his medical management. I don't think so. I have a hard time believing that. At first, until the body cam footage came out, I actually believed that you did care about your father and partially take care of him with your mom. And maybe that's why you lived in the little casita, is to help your mom. I now don't think that. Now, I'm not saying I don't believe that she loves her dad or she doesn't care about him. I do believe she loves her father and that she does care about him, but not in the way that she tries to portray to the world and the way that I thought she cared about him. Number 2, petitioner's medical condition. Petitioner has been advised to receive urgent evaluation and treatment for gestational bleeding. Where is your attached medical records? 1, so they can be verified that you didn't make them up. 2, who has advised you of this? A hotline? You don't attach that either. Did you go to the ER and the ER wants you to follow up with a specialist and they found it? Like, where's your banner patient portal info to back this up? Not buying this story. Efforts to retain counsel. Petitioner has been declared indigent by a court in Arizona. She has actively sought legal representation in this case through the San Francisco Bar Association Lawyer Referral and Information Services, LRIS, and for the family legal clinic. She contacted both by October 1st, 2025. Ma'am, you filed this case, I believe, July 9th, your request, or you sought the temporary renewal, like you wanted the renewal then. At least by August 15th, you knew that you needed to start seeking counsel right around there or mid-August, because that's when David was going around saying, I don't represent you. And that's when he told Omar. So why are you just starting to look in October? 20 days prior to your long cause evidentiary hearing. 20 days before it, that's when you start looking? No. You knew you were doing this. No. And she says she remains on their waiting list. Both have said they will be able to assist if she can wait 2 to 4 weeks. There should be an email or something verifying this. Give the contact information of who you talk to. So if they need to call, they can say that this is real. These are legitimate ongoing efforts showing diligence and good faith. No, sitting on your ass until 20 days before your hearing is not diligent and good faith. Complete and public exposure of this matter. This case has been designated a long cause hearing and involves multiple pending motions and evidentiary issues. It also has drawn public attention through a group known as Justice for Clayton, which reposts and comments on case filings. And you know why the public nature of this case does not matter? Is because there is no jury pool to be tainted. No jury pool to be tainted. And so, yeah, it's going to be a judge on this case. So the judge knows what to consider and what not to consider and doesn't give a crap about anything that's going on that's irrelevant to this case. The harassment and publicity surrounding this matter are described in prior filings by attorney David Gingras. Petitioner requires counsel to ensure filings are accurate, complete, and not misused publicly. How can we misuse public court filings? They don't get misused. We read the page, we read what's on the page, and then we express our opinions and compare it to evidence to evaluate and analyze if what we think is true and false in what somebody writes. But it has no bearing. This shit has no bearing on the judge who's going to be deciding this. 5. Efforts to resolve informally. Petitioner contacted opposing counsel Omar Serrato on October 6th and 7th to request a short continuance while she secures counsel and addresses these medical issues. Counsel has not stipulated to a continuance as of this filing. No, because you have drugged this on since 2017, 2018, and we're now fixing to be in 2026. You have had more than enough time. You have had 5 years preparing for this permanent DVRO. Why would Omar and Mike Marraccini agree to let you continue so that you have more days to try to come up with something to save your ass when you know there's nothing? You shouldn't have filed this. You're the one who brought the case. You don't need a continuance now. because you should have had all your evidence and everything ready the day you filed this case and requested this. And you know who doesn't need a continuance and who doesn't want a continuance is the people that are in real danger. They don't want to continue it. They want this stuff as soon as possible because they are in fear for their lives, and that is not you. You think you're safe for another 45 days without a piece of paper saying something. This is not real. You have done enough to people. When no need to continue this so that you can continue to torture people longer. Legal standard and argument. Under California Rules of Court, Rule 3.1332C, circumstances that may indicate good cause include 1. The unavailability of an essential layperson or expert witness because of death, illness, or other excusable circumstances. That's not the case here. The unavailability of a party because of death, illness, or excusable circumstances. You're available. The unavailability of trial counsel because of death, illness, or other excusable circumstances. Well, you don't have trial counsel, so that doesn't apply here. The substitution of trial counsel. Who are you substituting in? You don't even have a notice of appearance of anybody, from my understanding. And if you did, that person's not on the case because Jingish said he tried to file a notice of appearance, but it was rejected or not accepted on a technicality, whatever the fuck that means. She says she missed number 5. She went 1, 2, 3, 4, and 6. A party's excused inability to obtain essential evidence despite diligent efforts. Ma'am, you said you had all the evidence of the things that you accused him of. You were there, and David Gingras was there, and Mike Marraccini was there. Your mother was there on the day that Gingras called the cops at Clayton Eckerd in your hearing. So what other evidence do you need? You've got the police reports that say no, there was no violation. I'm sure you've got the transcripts from that hearing because you needed it for the appeal. So, on that part of everything that happened on June 10th, 2024, I'm not understanding what evidence that you can't find given your diligent efforts. And then the other evidence would be these 2,500 or 2,500 documents of text messages. If they're out there, why are you having trouble finding them? Because you're the one that said that they're out there publicly. So those are the evidence things that you would need. So what can you not find for your case? I mean, you're not going to find any evidence that proves that he's violated anything or done anything to you, no matter how diligent your efforts are. It's never going to happen. So I don't know what you're trying to look for. This is an excuse. This is a lie. It's bullshit. Petitioner's situation satisfies several of these examples: her temporary medical unavailability, her father's hospitalization, and her documented diligent attempts to secure representation all constitute excusable circumstances under the rule. Further, Rule 3.13 1332D directs the court to consider all the facts and the circumstances that are relevant, including the proximity of the hearing date, whether there have been previous continuances, the length of the continuances requested, and whether the interest of justice are best served by a continuance. No, they're not. Because you're the one that brought this, you're the one that wants to make this permanent. You either do it now or don't do it, in my opinion. Here, the hearing is less than 2 weeks away. Well, that's your fault that you sat on your ass and did nothing and thought that David Jingers was going to come save you, even though y'all made valiant effort. No recent continuance have been requested. Petitioner seeks a modest 45-day continuance, and respondent will suffer no prejudice. Yes, he does. While petitioner will face extreme prejudice if forced to proceed unrepresented in a multi-day evidentiary hearing. The thing is while yes, it's great to have an attorney with you when it comes to court. If you are a woman that needs a domestic violence restraining order and you need it renewed permanently, and you've had 5 years to come up with things, you should be able to have those. You should be able to say, look at these texts, Judge. Look at this Ring doorbell camera footage that he's been at my house. Look at this picture I took. You have nothing and you will come up with nothing because there is nothing. She says, given these factors, the interests of justice are best served by granting the continuance. Then she says, prayer for relief. Petitioner respectfully requests this court continuing the long cause hearing currently set for October 20th through the 21st for approximately 45 days, so such further time as this court deems appropriate. Adjust all associated deadlines for witness lists, exhibit, and briefing accordingly. And 3, grant such other relief as the court deems just and proper. Dated October 7th. And Laura Owens, respectfully submits this. Okay, and along with this, and I guess there was a correction somewhere, and I don't know if I already have it corrected in this or if that still hasn't been posted to the court, but if it's anything major, we'll let you know. So this is her new declaration, and really she should not be making any declarations. She shouldn't be. So she filed this with the Superior Court of California in and for the County of San Francisco. It says, I, Laura Owens, declare. I am a petitioner in this action. I submit this declaration in support of my ex parte application for continuance of a hearing currently set for a 2-day long cause evidentiary hearing on October 20th and 21st. See, the dates above say 21st and 22nd, and then in her writing she says 20th and 21st. So I don't know what date is right and what date is wrong and why she doesn't have the dates correct here in one of the statements. All right. Family medical. My father was hospitalized last week and continues to require significant care. I've been assisting daily. And now that this is your declaration, I was hoping you would have more information in this part, but you don't. And why I do not believe that you have been assisting daily, unless this is new for you and you just started assisting daily. But as the body cam footage shows, you didn't know he had a walker. Maybe he doesn't use it all the time. Maybe he uses it with assistance. I don't know how he's getting, well, I guess you put him in a wheelchair and you just wheel him and he sits in his wheelchair all the time. But that doesn't seem to be the case either, because he went to go sit in a chair. Well, he can't sit in that chair. Okay, well, he sat there just fine with help getting in and out of it. I'm sure he would have been fine. And then it was like, no, sit in this chair. And you wanted him to sit in a chair, and your mother's like, no, he sits in this chair. And she's like, it's Rolly. She's like, but that's the one he sits in all the time. So you don't even know what chair your dad sits in all the time. So how often are you really around him? Because there was a lot of things in that thing about your dad that don't line up with things that you have stated in declarations. Now, I'm not saying that he wasn't hospitalized and he wasn't sick and that he's not dealing with stuff, but you are not his caretaker. Your medical condition is your next reason. I have been advised to receive urgent evaluation and treatment for gastrointestinal bleeding, and I am undergoing ongoing medical testing and care. With what money? Do you have insurance? How are you paying for your insurance? We don't have a job. You paying for it with cash? Where are you getting that cash? Where did you get an urgent evaluation? You went to urgent care? Did you go to Banner Health? And they said that you had this or that you might have it or that is symptoms that can be associated with it. Have you had any imaging done for GI bleeding? Have you had a colonoscopy? Have you done the prep work for it? Prep work for colonoscopies? I've had gastrointestinal bleeding. I've had a lower GI bleed before. And hemorrhoids are not considered gastrointestinal bleeding, Laura. So, I am not going to believe until I see credible evidence that you are under treatment for gastrointestinal bleeding. You would also be hospitalized with as thin as you are. And you started having bleeding like that, you would be hospitalized. But yet you're not. And going to the emergency room or an urgent care does not count as you being in the hospital. You would be admitted into the hospital. I don't believe you, and you have no supporting evidence or paperwork to support your statements. And sadly, because you're not credible, you have to have receipts and proof to be believed. Then the next one is, of course, the efforts that she's been trying to get legal representation, um, long cause complexity and publicity, repost comments about the public nature. Yeah, she says the same thing here. Basically, this says the same thing as the other one. Okay, and then her meet and confer. I contacted Respondents Counsel, Omar Serrato, on October 6th and 7th to request a short continuance while I secure counsel and address these medical issues. As of the filing, counsel has not stipulated. She says that she wants the 45 days. And she declares under penalty of perjury under the laws of the state of California. And she did this in Scottsdale, Arizona. So she's under perjury of California law. But she wrote this in Scottsdale, Arizona. So I am wondering if the fact that she made these statements in Arizona, could another charge be added if they can demonstrate that this medical shit is false once again? or because it's for the state of California, if they can't bring a charge, they can definitely bring it into her case. Because any statement that's made, no matter where, who it's to, if it's publicly known, it can be used against you, and it will be used against you. So this might not have been a smart move on her with what she's facing. Okay, and before we get into Omar's filing, I also heard that I don't remember where I heard it from. I thought it was in one of the documents, but it may be something that was reported that she said in court on the 10th when they heard her the motion to disqualify, the motion for sanctions and strikes and referral to the state bar, and for Owens' continuance, which the judge denied all of them. The disqualification of David Gingras was denied without prejudice. So if David tries to reenter, Omar can file it again. But I don't fully quote me on this, but I swear I heard somewhere that Owens was saying the reason she was looking for a lawyer now or whatever it is she thought that Gingras was going to be able to represent her, which baffled me because why would she think that David Gingras was going to represent her if he's been saying he's not the entire time? Has Gingras been telling her that he will? We just got to make sure that I don't get disqualified in this motion, and then if I don't get disqualified, then I can represent you. Or has he been telling her and she's just not been listening? Like, look, Laura, I can't represent you in this because I'm a witness and I am here to support you and I'm going to be on your side and tell the story the way you want it. But I can't be your attorney for that. And so, and she just thought that he was going to be allowed to do both. So I don't know if Gingras is telling her this and she's not listening or if Gingras and Owens have been planning this thing to where she thought that this was going to be allowed. And so now she's like, well, I just recently realized that he wasn't going to be able to be my attorney. And it's like, ma'am, you should have known that for months by now. So it's still not a great excuse. And it either makes you look like a liar and the fact that you don't listen because you're too stubborn, or it makes you and David look like y'all been scheming stuff in the background. Either way, it's not a good look. Like I said, I believe that's something I heard that she said something about that. If you know where that is from, where she thought Gingras was going to be able to be her attorney and the court shut her down or she just recently realized it or something, let me know where that statement came from because I don't fully remember. But I thought it was in the documents and it wasn't. And so I'm like, ooh, let me address that now because I don't technically have anything to back it up with my own eyes and ears. It's just something that I thought I heard somebody mention. It could be wrong. It could be true. I don't know at this point. So, okay. So Omar filed a notice of expert witness um, in the Owens v. Marraccini. It says, please take notice that pursuant to California Code of Civil Procedure, Section 2034.260, the undersigned hereby designates the following expert witness whose opinion testimony is expected to be offered in evidence at trial In the above entitled action, California Code Civil Procedure 2034.260, expert witness designation, name John Berryhill. It's got his P.O. box. Field of expertise is forensic analysis. Pursuant to California Code of Civil Procedure and that section, the undersigned attorney provides the following expert witness declaration under penalty of perjury, and that's California rule. Number 1, qualifications. John Berryhill possesses specialized knowledge, skill, experience, training, and education sufficient to qualify as an expert witness in forensic analysis. Mr. Berryhill has extensive experience in forensic examination and analysis with particular expertise in the methodologies and procedures relevant to this case. His qualifications include specific qualifications to be detailed based on experts' credentials. General substance of testimony. Mr. Berryhill is expected to testify regarding his forensic analysis and finding as documented in his expert report completed in 2024, according to the California Code. His testimony will include the introduction and authentication of his forensic report and the presentation of his professional opinions based on his examination and analysis of the evidence in this matter. Mr. Berryhill will testify regarding the methodologies employed, the reliability of the forensic techniques utilized, and his conclusions based on the evidence examined. So the thing is, he needs to say, yeah, we've seen the report, but we need an expert witness, to be deemed an expert, it needs to be an accepted methodology. In other words, it has to be an accepted way to get these things and come to these conclusions. What method does he do? Do other forensic analysis people use those methods or use those tools? And tell us, how do you know? Is it based on this metadata, or is it because of this code, and where did this code come from, and stuff like that? Like, they need to be able to break it down and explain why what everything in this report says is true and accurate. And so he's going to be able to do that, and he's going to be able to give his opinions. 3, agreement to testify. Mr. Berryhill has agreed to testify at trial in this matter. Familiarity with the case. Mr. Berryhill will sufficiently familiar with the pending action to submit to a meaningful oral deposition concerning this specific testimony, including his opinions and their basis, that he is expected to give at trial. So he is willing to submit to a deposition about his findings and what he would be testifying to. Expert fee. Mr. Berryhill's hourly fee for providing deposition testimony and for consulting with the retaining attorney is $500 per hour, and his daily fee for trial testimony is $2,500 per half day, because you need to know how much they're being paid and things like that. It's very common in cases that you'll see, well, how much were you paid by this side to say what you wanted to say? All right. Foundational materials. Mr. Berryhill's expert report completed in 2024, and all documents relied upon by him to reach his conclusions will be made available as required. The report and supporting materials provide the foundation for Mr. Berryhill's expected testimony and will be produced in accordance with discovery obligations. Authentication of expert report. Mr. Berryhill will provide testimony necessary to authenticate his 2024 forensic report as a business record or through his personal knowledge of its preparation and contents. The report was prepared in the regular course of his professional forensic analysis practice and will be properly authenticated for admission into evidence. Notice regarding compliance. Please be advised that an objection of any party who has made a complete and timely compliance with Section 2034-260, the trial court shall exclude from the evidence that expert opinion of any witness that is offered by any party who has unreasonably failed to list that the witness as an expert, submit an expert witness declaration, produce reports and writings of expert witnesses, and make the expert available for a deposition. This expert will be made available for deposition under Article 3, commencing with Section 2034.410 of the California Code of Civil Procedure. And so he's saying that if there's an objection to this of any party who has made a complete and timely compliance with this, the trial court should exclude it. But I think that is also kind of letting Laura know that, one, you can depose him if you so choose, Laura. And if you so choose to hire your own expert, you need to make sure that they are available for Omar to depose them and do a similar type notice to him in a timely manner. Certificate of service. I hereby certify that the true and correct copy of the foregoing notice of expert witness designation was served upon all parties in the above entitled action by the method indicated below and in accordance with California Code of Civil Procedure Section 1011 or 1013 and so on. Respectfully submitted by Omar Serrato on October 7th, 2025. So I am thinking that when Gingras complains that he didn't get a notice of a certain witness or expert witness or whoever that he talks about was going to testify, that Woodnick didn't do this. He didn't give him notification properly and he wasn't, informed about what he was going to be testifying to and all this other crap. I'm thinking Gingras wanted one of these notices and he didn't get it. I don't know that he needed to do that. But here we are. Omar filed this, so Laura knows that this guy is going to testify. So this shit is coming in, whether she likes it or not. But that is it for this document. And I will be back with another video very soon. Bye.